Now imagine a crime scene that literally spans continents. There are no physical weapons here, no broken safes, definitely no obvious getaway cars. Instead, the alleged weapons are just computer screens. And the target? The very currency of an entire nation. So how exactly do you prosecute a cartel when the suspects are completely scattered across the globe, hiding behind international borders? It is basically a prosecutor's ultimate nightmare. Well, today we're going to dive right into this incredible cat and mouse game of international law and economics. To really wrap your head around the sheer gravity of this, we just have to look at who is actually being accused here. We aren't talking about small-time back-alley operators. We are talking about some of the absolute most powerful financial institutions on the planet. I mean, JP Morgan Chase, Credit Suisse, Bank of America, BNP Paribas, HSBC, Macquarie, and a bunch of others. The Competition Commission of South Africa accused these absolute titans of colluding to manipulate the exchange rate between the US dollar and the South African rand. The scale of these allegations is just monumental. So, welcome to this explainer. Today, we're unpacking the dragnet, prosecuting the alleged rand manipulation. We are going to explore exactly how South African authorities attempted to cast a massive legal net across the entire world to drag these financial behemoths into a courtroom. It's a wild international legal chess match that went all the way up to the highest court in the land. Okay, here's our roadmap for this explainer. We'll quickly cover the timeline of the alleged rand manipulation, we'll untangle the whole jurisdiction puzzle, track the courtroom ping-pong, look at the escalating legal battle, and then finally break down the overarching conspiracy that glues this whole thing together. Let's get into it.
Section 1. The alleged rand manipulation. Investigating a borderless crime.
You know, this legal saga didn't just stop at some lower tribunal. It escalated all the way up to the Constitutional Court of South Africa. And that really underscores the immense legal complexities at play when a sovereign nation tries to hold foreign entities accountable for local economic damage. Because manipulating a national currency, that is definitely not a victimless crime. It affects everyday inflation, international trade, the livelihoods of ordinary citizens. It literally raises the stakes of this prosecution to the absolute highest possible level. But, as they say, the gears of justice grind pretty slowly. The Competition Commission alleged that starting back in 2007 and going all the way until at least September 2013, these banks colluded to manipulate the US dollar and South African rand exchange rate. The formal complaint was initiated in April 2015, and by February 2017, the case was officially referred to the Competition Tribunal. At that point, they named an initial 18 respondents. But as we're about to see, simply naming them on a piece of paper is one thing. Actually getting them to show up in court is an entirely different story. Which brings us to Section 2, the jurisdiction puzzle, categorizing the suspects. To actually untangle this mess, the authorities essentially had to create a giant suspect board, sorting the banks into 3 very distinct legal buckets based entirely on where they lived and operated.
The first bucket is what the law calls an incala. Basically, these are your local, natively domiciled South African banks. Think of the Standard Bank of South Africa, Absa, Nedbank, or FirstRand. For the prosecutors, this is the easy bucket, right? The South African courts obviously have clear, unquestionable jurisdiction over their own local entities. No problem there. Then we move to the second bucket, the local peregrini. Now, these are foreign banks, but they do have a local footprint. So maybe they have a physical branch or an authorized representative office right there in South Africa. Examples in this case were BNP Paribas and Citibank. Because they have an actual physical presence, the courts have a hook. They're authorized under local law to deal in foreign currency and do business in the country, which gives the tribunal a pretty conventional, straightforward way to exercise authority over them. But here is where the legal fireworks truly start going off. The third bucket, the pure peregrini. These are the pure foreigners, foreign banks with absolutely zero physical footprint or presence anywhere in South Africa, like Macquarie or Credit Suisse Securities. They're operating thousands and thousands of miles away. So how on earth can a South African tribunal force a bank sitting in New York or Europe to stand trial? Unsurprisingly, these foreign banks use those international jurisdictional borders as an absolute shield. And that clash became the central conflict of the entire case.
So how did the court actually navigate this? Well, they relied on 2 massive legal tests. First up is the ACF test, or adequate connecting factors. This is used to prove personal jurisdiction, basically asking, does the court even have the right to drag this specific foreign entity into the courtroom? The second is the QE test, or qualified effects. This proves subject matter jurisdiction. Does the court have authority over the specific topic of the crime? To pass this QE test, the Commission had to prove the foreign conduct had a foreseeable, direct, immediate, and substantial effect right inside South Africa. And the kicker? You absolutely need both of these tests to successfully prosecute the pure Peregrini.
All right, Section 3, the courtroom ping pong. Trib I versus CAC I. This incredibly dense legal debate caused a massive back and forth between the lower Competition Tribunal and the higher Competition Appeal Court. The clash of legal minds here is just fascinating. In their very first ruling, which we call Tribe I, the lower Competition Tribunal essentially said, look, our common law hasn't evolved enough to grant personal jurisdiction over these pure Peregrini. But then, oddly enough, they said they could still issue a declaratory order against them just to help out future civil claims. Well, the banks appealed this immediately, and the higher Competition Appeal Court, in a ruling known as CACI, completely overturned it. The appeal court said it's totally illogical to grant orders against entities you don't even have personal jurisdiction over. However, they did throw the prosecution a lifeline. They said, you know what? You might be able to get personal jurisdiction over these pure foreigners, but only if you go back and write a brand new affidavit proving those adequate connecting factors.
Section 4. Escalating the legal battle. The superseding affidavit. Because challenged by the appeal court, the Competition Commission definitely did not back down.
28. When the Commission filed their massive, brand new, superseding affidavit to satisfy the appeal court in June 2020, they didn't just add more details. They literally added more banks. They brought in 5 local South African banks like Nedbank and FirstRand, bringing the total number of respondent banks to a staggering 28. Why? Because connecting the foreign banks to an alleged conspiracy that actively included local South African banks was a brilliantly crucial connecting factor. It was the key to help prove that the South African courts actually did have personal jurisdiction over the foreigners.
Naturally, the banks fought back hard. They filed endless exceptions, arguing the Commission was breaking procedural rules left and right. But in a subsequent ruling, Tribe 2, the tribunal flat-out rejected the bank's technicalities. They explicitly stated that their guiding principle is fairness, specifically because these referral proceedings are such a unique intersection of law and economics. They essentially said, look, we are not going to let an alleged cartel off the hook just because of overly technical, nitpicky procedural arguments at an early stage. The stakes for the entire South African economy were simply way too high for that.
Okay, so how exactly does the Commission plan to link a trader sitting at a desk in New York to a totally different bank down in Johannesburg? Let's get into Section 5, the overarching conspiracy, proving the SOC. Now, the Commission didn't try to argue that all 28 banks magically sat in a single smoky back room together. Instead, they relied on a really clever concept drawn from European Union case law, a single overarching conspiracy, or SOC. To prove an SOC, you don't need everyone to meet at once. You just need to prove these 3 specific steps. 1. An overall plan pursuing a common economic anti-competitive objective. 2. Intentional contribution by each firm through their own actions. And 3. That the firm either knew about the actual conduct planned by the others, or they could have reasonably foreseen it and were totally prepared to take the risk. If the Commission can prove those 3 things, boom, that whole 28-bank borderless web becomes legally tied together. And that brings us to the ultimate question, doesn't it? This case represents a grueling, decade-long game of multi-dimensional legal chess, fighting over complex definitions of jurisdiction, adequate connecting factors, and qualified effects. It forces us to ask, what does this massive procedural battle mean for the future? As our financial systems become increasingly digital, instantaneous, and truly global, could this incredible case out of South Africa permanently rewrite the playbook on exactly how nations hunt down and prosecute international financial cartels? Thanks for joining me on this deep dive into the source material. I really hope this explainer brought some clarity to what is a truly fascinating legal puzzle.